From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Supreme Court hears a case on political gerrymandering from North Carolina. But what's at stake, and do the justices have a clear path forward? Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Kim Strassel and Alicia Finley. Welcome and happy Thursday to you both. On Wednesday, the Supreme Court heard a case called Moore v. Harper, and it involves the Constitution's Elections Clause and could have broad implications across the United States. The background of the case is that after the 2020 census, the North Carolina legislature passed a new House redistricting map, and it was favorable to Republicans, giving them an advantage in 10 of the state's 14 House districts. But that map was struck down by the North Carolina Supreme Court, and the judiciary then drew its own map as a replacement. So, Kim, maybe that's the place to start. Can you give us a sense of what the North Carolina Supreme Court did that is so controversial in the first place?
Yeah, and let me just give a little background here because I think it's important. State courts and state legislatures and these redistricting maps have become much more political in recent years, in part because the former Attorney General, Eric Holder, Barack Obama's Attorney General, when he left office, he was very concerned about Republican dominance down ballot and at the state level. In particular, their sway over legislatures and state Supreme Courts. So he began this whole new project to try to both flip state legislatures in Democrats' favors, but also to get more Democratic judges appointed at state Supreme Court level, so that if these partisan gerrymandering maps came along and Republicans were the ones producing them, they would have a kind of fail-safe at the court level that would strike them down. And he was quite successful in doing so. This has put new attention by Republicans on this question. In this last election that we just had, there was an enormous effort by Republicans to capture back some of those courts. In fact, they did so in North Carolina and in Ohio, where you'd also had a court strike down a legislative map. But their other way of going at this has been to make the argument that it should only be legislatures that are allowed to engage in this process, given the U.S. Constitution says that the details of congressional elections, meaning federal elections, shall be prescribed in each state by the legislature thereof. And the proponents of this note that the courts aren't mentioned, and that the problem here is that the North Carolina legislature prescribed a map and the state judges threw it out and just put their own replacement in it. What is the limiting principle, therefore, of a state court engaging in what the Constitution certainly seems to suggest is a legislative function? That is what the supposed offense here is by North Carolina. We've seen it happen with other courts too, and that was what was put before the High Court this week.
And by the way, the North Carolina Supreme Court struck down this map as a partisan gerrymander, but the North Carolina Constitution actually doesn't say anything about partisan gerrymanders. So the state justices were pointing to some language about free elections, a right to assemble, freedom of speech, equal protection of the laws, and so forth. But a couple of justices, at least, I think, to my read of their questions, very skeptical that this is a justification for what the North Carolina Supreme Court has done. To pick up on the point about the Elections Clause, the Constitution says that this is a power given to legislatures. And so the argument on one side of this case is that the legislature has to draw the maps, and anything in the state constitution, even if it's explicit, New York is a state where there is explicit language banning partisan gerrymandering, that can't be binding on the state legislature. The other side of this argument is that when the Constitution gives this power to the legislature in the Elections Clause, what comes along with that is any sort of normal process and procedure that goes along with state lawmaking as the state sets that up in its constitution. And so that could include a gubernatorial veto, that could include judicial review. One point that I thought was interesting, raised in the oral argument by people who see a stronger reading of the Elections Clause, is a precedent from 1922. And they are pointing out that there's similar language in the Constitution around the ratification of U.S. constitutional amendments. They need to be ratified by state legislatures. Well, when the 19th Amendment, which gave women the right to vote, was being passed, there were some states that didn't want it, and they tried to block it. And the question that came before the U.S. Supreme Court was whether a state can put into its constitution that the state legislature cannot essentially approve of a constitutional amendment that changes the franchise and extends the franchise to women. And the U.S. Supreme Court said the function of a state legislature in passing on a proposed amendment to the federal constitution is federal and not subject to limitation by the people of the state. And so, Alicia, that's a fascinating precedent, I think, and one that the people in favor of a strong elections clause reading were citing several times during oral argument.
Right. So there's the supremacy clause in the Constitution that holds that generally federal laws in the U.S. Constitution trump state laws and the state constitution. But the flip side of this is that, there is federalist principles too, and to what extent, how broadly do you interpret this election clause is, I think, really what the justices were grappling with. There's one argument that, well, the governor has the power to veto these maps. The governor, even though he's not part of the quote-unquote legislature per se, he's involved in the legislative process, and therefore that's kosher, so to speak. Whereas judges their role is purely to interpret laws in the Constitution. They have no actual role in legislating. Here, what really strikes me as perhaps the biggest offense isn't that merely that the North Carolina Supreme Court struck down the maps, but also that they essentially appointed a special master to redraw them. So essentially the judges were acting as legislators. And I wonder if the question wouldn't be so fraught if the judges, again, merely struck down maps, said and returned it to the legislature and just directed them to redraw them. I don't know how that would have played out. We do see that happen in other states where judges just strike down the maps and tell the legislatures to redraw them and continue and go with the old maps. So, and again, this also happened in New York where the judges appointed a special master to redraw the maps. And this is, again, what I find troubling is where you actually have judges come in, not just act as interpreters of the state constitution, but actually are playing the role of the legislature, which, as you point out, the elections clause, it's vague, but legislature means legislature. It does not mean judge.
The veto point I want to pick up on because I think that's a fascinating facet of this too. So this is a 1932 Supreme Court case that said when there's a districting plan that is going through a legislature, it is subject to a gubernatorial veto if the normal lawmaking process in that state involves a gubernatorial veto. And that is not being disputed in Moore v. Harper this week. But it is interesting, I think, how Justice Gorsuch handles this question. Listen to this.
It is a small point, but on Smiley, on the veto question, just narrowly on the veto question, Locke, Montesquieu, the Federalist Papers treat that as a legislative power and a sharing of the legislative power. And it's in Article 1, which kind of suggests the founders considered it a legislative power.
I thought that was a fascinating response. I went and looked up Article 1, and sure enough, that's where in the U.S. Constitution the presidential veto is. So he is suggesting that is not an executive power at all. That is a delegation of legislative power to the executive. He's sharing in the legislative power. On the other hand, the line between substantive limits on what the legislature can do and procedural things like a veto can get a little blurry at times. Justice Sonia Sotomayor brought up the idea of a line item veto, which she says in more than 40 states, these provisions empower governors to accept or reject legislation by altering its content. And that can be pretty narrowly done. There's one famous example, I think in Wisconsin, where there was a $25 million appropriation that was passed, and the governor vetoed the number 2. And so it became a $5 million appropriation. And so then this gets even more vexing, I think, to me, Kim, is if a veto is okay because that's a procedural move, what about a line item veto where the governor is going through and only vetoing certain things? It gets pretty close to looking like he's rewriting what the legislature passed.
Yeah, and I think that that's why it was notable that Gorsuch was the one who brought this up. He also seemed to be, in the course of these hearings, the person who was most comfortable with the lawyer who was arguing on behalf of the independent state legislature theory, this notion that courts shouldn't have a role. And he was using this to kind of back that up, getting into, again, the supremacy of legislatures in all of this. But again, I think it's a fascinating point. I'm not sure it's necessarily going to resonate in whatever decision finally comes out, because it didn't seem to be one that other justices, even conservative justices, really have much time for. We can talk a little bit about how all this comes out and some of the alternate places that the justices might land. But I did think it was also a fascinating thing, and to draw those distinctions, yes.